And with that, we move on to our next session. Joining us is Shri Manish Tewari, member of Lok Sabha from the Congress. He will be moderated by Priya Sehgal, editorial director of Newsx, and they will be discussing the key successes and failures of the Indian Constitution. What a pertinent time to be having this particular conversation. Manish ji, thank you so much for joining us. Priya ji, over to you.
Thank you, Devika. And I welcome Manish, former Union Minister, National Spokesperson, and of course, one of the most articulate voices of the Congress in Parliament. But Manish, today it's really, we are rising above really party politics, and I really want you to take a look at the Constitution, because we are also celebrating 75 years. And, what would you say are the successes and the key successes and failures of the Constitution? I know it's too vast of this thing, but if you can just narrow it down into a few points.
Well, Priya, first of all, thank you very much for having me here. 75 years down the line, when we look at the Indian constitutional experiment, it can be said without any ambiguity that this experiment has been a success. Way back in 1946, even before India attained independence, when the Constituent Assembly met, some of India's finest minds, they did not get into the act of tearing down buildings and building new buildings. They actually sat down, the best of them, for over 3 years and created a document, a ground norm, which would guide India's destiny over the next decades. And there are many countries in the world where constitutions have been scrapped, constitutions have been rewritten, where republics were founded, republics got extinguished. But in India, the Constitution has not only endured, but it has thrived. And to a very, very large extent, the credit goes to the Supreme Court. Because in 1973, when the Supreme Court, by a sliver of a majority of 7:6, put the basic structure doctrine into place, that actually, if I may say, saved the Constitution from being amended in a manner whereby its originality would have been lost. And so therefore, if you look back, there have been jurisprudential milestones on that journey which have only served to strengthen the Indian constitutional experiment.
But we've also had, this conflict between the Parliament and the judiciary, in terms of even where the basic structure is concerned. So can you, walk us through some of those milestones?
Well,
one second. Can we have no silence at the back, please?
Well, that stress is natural in a democracy, because obviously between Parliament, which represents the sovereign will of the people, and the Supreme Court or the judiciary, which is the final arbiter of the Indian constitutional scheme, if there wouldn't be tension, it would have been unnatural. So therefore, the fact that there is tension and at times there is even conflict serves to balance out various interests. And if you go back to the founding years of the Indian Republic, you had a very conservative court, and you had a progressive parliament which wanted to fulfill the commitments that it had made. And so therefore, many of the original constitutional amendments, the creation of the ninth schedule in order to make that immune from judicial challenge, were some of the innovations which Parliament had evolved in order to insulate and firewall scrutiny, judicial scrutiny on each and every action. But the court has been equally progressive and proactive, and it has stripped off or stripped down, each of those so-called firewalls which Parliament had built and has actually made everything amenable to judicial review, which in any democracy is really a very good thing to do.
That is because you're on this side of the fence. When you were in government, were you so happy with judicial review?
Well, judicial review is a functionality which the courts must exercise, because after all, Parliament is also a creation of the Constitution. Parliament is a creature of the Constitution. The judiciary is also a creature of the Constitution, and the whole doctrine of separation of powers is really predicated upon the executive, the legislature, and the judiciary balancing each other out. But unfortunately, in a Westminster-style democracy, when the executive and the legislature fuse together, so therefore, and then you have what I call whip-driven tyranny, which runs the proceedings of the legislature, then who really acts as a check or as an arbiter on the excesses of the executive? And that is only the judiciary. And they do it through the process of judicial review.
We've had, the recent Places of Worship Act. We've had the court stepping in. Your take on the debate, and also was the act open to review, the 91 Act?
Look, if you go back to the very writing of the Constitution of India, even though the word secular may have been included by the 42nd Amendment in 1976, but the Indian constitutional design per se was extremely pluralistic in nature. And therefore, if you look at the fundamental rights, the kind of protection which has been given to both your right to profess, propagate, and follow your faith in the manner in which you think it is appropriate, the protection which has been given to the minorities, were all a part of the basic design of the Constitution. So therefore, if you start really unraveling history, or if you start digging into the past, the question is, where does it stop? Does it really stop in the 15th century? Or would it really rewind back to the 17th century? Or would you like to rewind back to the before Common Era? So once you start taking a revisionist view of history, there is no stopping you, because you may then want to draw the line here, but then somebody will come and draw the line further to the right. So under those circumstances, I don't think it serves us either as a republic or as a society if we keep taking these revisionist views, because you are essentially then trying to look at the destiny of India through a rear view mirror rather than moving forward.
But there is also this whole debate around the word secular, that it was added later, and should we now drop it? And they're saying the review of the Places of Worship Act is also against the principles of secularism, the act itself.
Well, the fact is that the Constitution of India, or its preamble as it stands, does talk about a sovereign, democratic, socialist, secular republic. So therefore, that is what we are. Now, whether it was added later or it was there at the inception is neither here or there, for the simple reason the Constitution of India, as it stands today, is after almost 100 or so amendments. Then are you going to say that, this amendment is correct, but that amendment which does not suit us is incorrect? So those who talk about the purest theory of the Constitution forget the fact that it is a living document. And it's a living document which has been adapted to the changes which have come about in the polity and society over a period of time. So this cherry picking that this amendment suits my political predilections and that amendment does not agree with my ideology or philosophy is frankly a non sequitur of an argument.
Which, in your view, is the biggest failure of our constitution?
Well, that's an interesting question. And if you actually go back to the debates of the Constituent Assembly, the Indian constitutional scheme as it was conceived was supposed to have powerful states and a weaker center. But when the partition of India was agreed upon in the June of 1947, the 6th of June 1947, if I'm not mistaken, the pendulum swung 180 degrees. So the Union Powers Committee, which was a part of the one of the committees of the Constituent Assembly, then decided to have a stronger center and relatively weaker states. And therefore, the whole mechanism of the concurrent list and a lot of powers being put into the concurrent list in order to give both states and center the right to be able to legislate on them, in my opinion, represents a failure of our constitutional scheme for the simple reason that the balance between the states and the center somewhere got lost in the process. Because if you go to Article 1 of the Constitution, it says that India is a union of states. And it in the very first article of the Indian Constitution. And therefore, that's why from the early 50s itself, you've had this raging debate on federalism with the states, irrespective of, whatever shade of politics or political hue they were represented by at various points in time, have always been clamoring that the states require greater flexibility, a greater amount of autonomy, greater legislative space. And therefore, I think in the founding years of the Indian Republic, given the manner in which the Republic came into existence, did end up skewing the balance in favor of the center and against the states. And that's a balance which, unfortunately, for reasons best known to our subsequent generations of parliamentarians, we decided not to correct.
Well, national parties feel that it's better to have a stronger center. But we've also now, there is the talk of increasing the number of seats in parliament. The southern states are saying that, we are going to be penalized for, our policies and population. So where is the way out? Because the government is very adamant on going ahead with this.
The question is, how are you going to run that parliament?
That is also true.
It's already difficult to run a house of 543. How are you going to run a house of 750, 1,000? If you want to convert it into the National People's Congress, which is just a figurative rubber stamp of a legislative institution, then it's a different matter. I think this whole business of increasing seats in Parliament needs to be very, very carefully thought through, because after all, the primary function of Parliament is to make laws for the country. That's the fundamental function for which Parliament has been conceived. And the process of making laws requires a very sustained deliberative effort. And therefore, if you are going to have a larger number of people in Parliament, primarily because when the number of 543 odd was agreed upon, you had an X population of the country, and now you have an X plus plus population of the country, then you will also have to really see as to whether then you need to strengthen the committee systems, whereby you'll have to make it almost mandatory that every legislation then goes before a committee to be properly scrutinized. I would find it difficult that in a house which is larger than what the current Lok Sabha or the Raj Sabha is, thoughtful deliberation on national issues and especially legislation would then be easy.
But we're also talking, we're having this debate on one nation, one election. Where do you stand on that? Because, of course, the government is saying we're trying to streamline the process, we're trying to prevent wasteful expenditure.
Look, you'll have to really see the draft of what the government has conceived in terms of legislation, because till the time you do not see as to what that legislation is, it'll be completely inappropriate to comment about it. You can shoot the breeze till the time the cows come home. But essentially the draft needs to be seen, because eventually what really happens when the electoral cycle breaks down in a particular state, or when the electoral cycle breaks down even with regard to the national legislature. And then if you are going to really re-elect a national or a state legislature for the remaining period of that term, are you then really saving money or are you wasting money? If money is the argument that you are making, is something which is moot. So therefore it really has to be seen as to whether even constitutionally it is feasible. Because let's not forget, federalism has been held to be a part of the basic structure of the Constitution. Now, if federalism is a part of the basic structure of the Constitution, then even under Article 368(4), whereby an amendment which impacts the states has to be passed by half the states, would not also come into play. Because if there are certain features of the Constitution which are unamendable, till the time Kesavananda Bharati holds the field, how really are you going to even implement it? It will fall foul of the basic structure doctrine. So I think I have not really applied my mind to either the report which this commission under or committee under former President Mr. Kovind has given its report, but it would be interesting to see. But off the bat, I can say that the whole construct of the one nation, one election will fall foul of the basic structure doctrine.
That's a very good argument. But finally, how relevant is Parliament today? We've seen the opposition protesting more outside than inside. Shouldn't you take your protests inside where it really matters? Because you have the rest of the year to protest outside.
Well, so there are two answers to that. The first answer is that Parliament will have to very, very seriously look at the 10th schedule. Because while the anti-defection law has failed in its principal objective of curbing defections, it has sucked democracy out of Parliament. So therefore, legislative institutions, as I said, have become handmaidens of whip-driven tyranny. Number two, Parliament is for whom? Is Parliament only the preserve or the prerogative of the government of the day? Or does the opposition, in terms of raising issues of people, is an equal stakeholder in the parliamentary process? And that's a question which unfortunately has never been answered. In fact, I had suggested it to one of the presiding officers in an informal conversation that if you want to keep Parliament in play without disruption, all that you need to do is between 6 and 9 in the evening, twice or thrice a week, have a Rule 193 discussion on a subject, agreed to by the joint opposition. So therefore, you will have Parliament functioning very smoothly, because ultimately the logjam is the opposition wants certain issues to be discussed. The government is diffident about that. It leads to an unnecessary logjam. And so therefore, government has to show flexibility and magnanimity. And if, let's suppose, you're able to find a modus vivendi whereby the concerns of the government and the concerns of the opposition are both accommodated, Parliament will run very smoothly.
Okay, finally, Manish, which is the debate that you really enjoyed, as an MP, so taking part in over the years? You've been an MP for 15 years, right?
Well, I think the quality of debate in Parliament and I say this with all respect, was much, much better before the anti-defection law came in. Because when you had to walk the extra mile to actually build a consensus, not with the opposition alone, but within your ranks also. And there was actually a premium on everybody's vote. The propensity to participate in parliamentary proceedings was far, far greater because you knew that you could actually contribute to making a law or a policy better. But unfortunately, at 2 o'clock in the afternoon, when Parliament meets for its principal business, that is legislation, the House is empty, more or less. And there's an unwritten understanding between the Treasury and the opposition benches that the quorum call will not be made. Because if a quorum call is made, Parliament would get adjourned.
That is true. Finally, we've seen, Parliament debates and primetime television debates. The functioning of the media and the Parliament. Do you see that the media is actually, as a more disruptive force or as a more positive force? Because we are raising issues that are not being debated in Parliament, at least being debated outside.
Well, I think what used to be called new media about 20 years back, which is television, I think is old and fossilized media today. And so therefore the entire pattern of media consumption has completely and absolutely changed. The plate has become the mobile phone really. And there are far, far more diverse and active platforms which have become the primary sources of media consumption. So under those circumstances, how really relevant do they consider Parliament to their lives, is a moot question. But eventually, if Parliament keeps itself in play, Parliament keeps functioning, and people see it as an institution which is prone to working and not disruption, I think even the quality of media debates would also get much better.
Otherwise, I think social media is becoming the new Parliament, and influencers are the new MPs, I think, by the end of it.
Well, I think Twitter or X has also become old media, because if you talk to younger people, they say that Twitter or X or Facebook is for the 40 or the 50 plus. That's what I'm saying, that the whole patterns of media consumption are changing or have changed so rapidly that that is a subject of, I must say, a longer and another discussion.
But whenever we interview Manish Tewari, sorry? Exceptions always, yeah, sitting right here. But with Manish Tewari, one must always have a dictionary in hand whenever I used to interview him. But, have you also changed your language and simplified it for the Twitter X generation?
Well, my language is what it is. And if somebody cannot figure it out, I think if they go and consult a dictionary, they learn a few additional words also.
Educated husband. Thank you so much, Manish, for this conversation. Thank you.
Thank you so much, Manish ji, for joining us. I request Kartikeya Sharma ji to please join us on stage to present a token of our appreciation to Shri Manish Tewari, Member of Lok Sabha of the Congress.